Brandon, thanks for your help. And Cole and Brandon, thank you very much for watching my flight deck. So anybody who's joining us, we're going to give it just a couple more minutes to get up and go on, probably start a few minutes after 3. But I really, really appreciate everybody who's attending today. Melissa, you may not have heard this, but years ago, I had the good fortune or misfortune to deal with, I think it was your office, and you guys were great to work with. Very balanced. I had a unanimous decision in my favor that everything was done just fine. But I applaud the professionalism of your office, because going through it, which was very intimidating at first, really just assured me you guys are A, looking out for the better good, B, providing things in a very balanced format. And in the end, I was ultimately glad that we had went through the process.
And you haven't been back.
And I haven't been back.
Well, that's always great.
And I say this to the attorneys that I work with, save maybe for Angela, because we see each other a little bit more often, and the mechanics. Love all you guys. It's just when I have to see you, sometimes it's not good. So Angela, it also sounds we might have some other updates at the end of this session. We hear something on the news yesterday.
Yeah, I've got a few more sort of rent relief type stuff to update folks on at the end. So
excellent. So to anybody who's just joining us, again, we'll start in just a couple more minutes. Please feel free to post your questions in the chat. We'll coordinate and try to get to them as we go along, or towards the end as is appropriate. The more involved people are in asking questions, the less pontification you'll get from myself, Angela, or Melissa, and I say that with humor.
So Brian, I'm going to interrupt you because we want people to post in the Q&A. The chat is actually disabled, so please post your questions in the Q&A. It allows us, it's easier for us to moderate questions coming into the Q&A.
Excellent. Thank you for that interruption. Well, with that, before I create any more gaffes or schedule mishaps, I'd like to thanks everybody for showing up today. I really appreciate Angela, the Vermont Apartment Owners Association. I can't stress enough, if you're an agent, if you're an apartment owner, I strongly encourage you guys, join the association. They've done a phenomenal job for, how long you guys been doing this? About 25, 30 years?
I mean, Stuart started in 1974. So,
wow.
And I've been with the association since 2003. So almost 20 years for me.
Absolutely. Phenomenal resource. It's well worth the money. I'm not a tax advisor. I am told that it's a tax deduction as well, but check with your tax advisor. My name is Brian Armstrong. I'm the CEO of KW Vermont, Strongwell Property Management, and the Strongwell Real Estate team at KW. We encourage you guys to check out our sites. Ask us any questions that we can do to better help you guys bring value to your mission. And I'd like to welcome Melissa Horwitz from the state of Vermont. Melissa works with fair housing, better helps us respect the better good for all. And for those of you just joining, I had a situation years ago, had a very challenging resident, sir, good soul, but just challenging perspective. I got involved with the, Melissa's department, and I found them professional, very, very fair. Also gave me pointers when I had questions of things that I could have done better. And while I had a unanimous decision in my favor, I walked away feeling much, much better about working with her department. And that was a very fair process. And this is all something I think we definitely need to hear of so we can grow to bring, improve the better good for all residents of our communities. Melissa, how's it going? And talk to us.
We're still here. We're working remotely right now, but we're, a state agency, but we get complaints not only based on fair housing, but also public accommodations and employment discrimination in state employment. We continue to get a lot of fair housing complaints during COVID. The most frequent complaints we get are based on disability. I think that's fair to say nationwide, but we do see a lot of complaints in all areas of, related to all protected classes. So I assume we'll get more into it as we go along, but I'm happy to answer questions as well.
So why don't I'm going to screen share and we're going to jump into presentation here. And I think, one of the things for us to start with, of course, now my screen won't advance, so that's awesome.
Zoom's been a little wonky this week.
Yeah, it's, so I think the important part to start with fair housing is, what is fair housing? I mean, what does this even mean when we're talking about discrimination, or use some of these terms that we're floating around here? And I think the big one is to remember that we're talking about a person's right to choose, and that they have that right to choose without discrimination, right? And is that fair to say, Melissa?
Absolutely.
And really sort of the common language takeaway for this is that, fair housing is the right to an equal opportunity to housing. So it's, not giving one group an advantage over the other. It's saying we want the advantage, it to be an equal and a level playing field. So that being said, what is housing discrimination, and what does this mean? There's, a lot of statutes on this, both federal and state. A lot of the state stuff mimics what's in federal, but Vermont has some, extra categories. We're going to run through all of those. So it's a prohibition on certain activities, and those activities are based on someone's status or membership in a protected class. And so I'm going to run down this long list. I'm not going to read all of these. So these are all the ones that are in the statute, in the Vermont statute. But really what we're talking about for this seminar is the one that's italicized, related to housing. So Melissa, do you want to talk about that one a little bit more?
Yeah, it's important to remember, besides the refusing to rent or sell, the things that we commonly look at, to remember that you cannot set different terms, conditions, or privileges, or provide different housing services or facilities based on a protected class. So, an example of this would be, that if you have, let's say, a Muslim tenant and a Jewish tenant, you couldn't allow the Muslim tenant to have like a 10-day grace period to pay their rent, whereas the Jewish tenant had to pay it on time. So you can't, those are like setting different terms or conditions within the providing housing services.
Right. And I also, we see it come up quite a bit when folks have children, particularly minor children. You'll see it with rules and regulations. And a lot of times landlords are trying to think from like a safety standpoint. So if there's, say, a pool on the property, they might institute a rule that says no children in the pool. Well, that's probably too far to the other extreme and would be considered a discriminatory practice. But, they can have sort of safety things. So no minor children or no minors in the pool without adult supervision, right? So Melissa, something like that would be allowed, but a blanket prohibition would not.
Exactly, yes.
Excellent. All right, so what are these protected classes that we keep talking about? We have two groups. We have the federal, and then we have Vermont sort of builds on what's in the federal system. So these are all categories that the federal government has said people who belong to these are protected under these fair housing rules. And then Vermont has added some more. So these are all of the groups that we deal with here in Vermont. And as you can see, there's very few people that would be covered under one of these categories.
Yeah, and then I think it's also important to remember with disability, that's kind of covers two different things. So someone can be um, discriminated against because they're disabled. Like, I don't want to rent to you because you're disabled, but there's also, they can be discriminated against because they've requested a reasonable accommodation, which I'm sure many of you have dealt with or had people request these for. So that's just another way that disability discrimination comes up, and we see that a lot. People asking for reasonable accommodations or modifications, and landlords do need to know how to handle that when that comes up. It's important.
Yep.
What would you say are the 2 or 3 most common and either well-intended or innocently ignorant, if there's such a phrase, violations, like people who think they're doing a good job, they're following the law, but in reality, there's some education they could benefit from?
Familial status is definitely probably number one in terms of meaning well. A lot of times people are concerned about things that, there's steep stairs, there's, a big drop off in a backyard um, because of children that, they feel like that would not be great for children. And so you'll see advertisements that say, not great for children. Oh, I don't think this would be a good place for kids. And that's just not allowed. So that's definitely a place where we have a lot of complaints that come in about that. Let's see. Yeah. And then, like I said, the disability is just, it gets tricky there. So we see people that don't realize that they're doing something illegal, but it is.
Yeah. So we wanted to do a little dive into sort of 3 bigger areas that we see where landlords can run into issues or have requests that come in that, if they're not handled appropriately, could create some problems for them. The first one is related to emotional support animals. I know I get a lot of questions about this. And it's a very sort of thorny area for landlords. Also regarding applications to rent, and then a final one just about sort of statements and being mindful of things that you say and things that you write, because that can also create some problems even if you didn't intend it. So with regard to emotional support animals, so this is confusing for folks because it's like a service animal, but it's a lot broader. So a service animal, which I think we all traditionally sort of think of, is the seeing eye dog, the animal that's allowed to go into public spaces like stores, restaurants, basically is able to accompany a person wherever they go. And so that is one standard for sort of out in the public. When we're talking about somebody's housing, it's a different analysis and a different standard. And it's a lot broader. So this is, an animal that somebody has that helps them with some aspect of their disability. And their disability could be something mental or emotional. And so it doesn't have to be sort of that typical seeing eye dog. It can be something broader or something else. So, and I think these are sort of the big kind of categories or things of that at least I see coming up. Somebody moves in and a month or 2 later, they request an emotional support animal, and the landlord's like, why didn't they tell me when they came in? Or, they get the dog. Tenants tend to do things out of order. So they get the cat or they get the dog, and then the landlord says, you can't have that. And then the request for the emotional support animal comes in. It's allowed. It's allowed under the rules. And I understand and I appreciate that it's frustrating. It's just the way the body of law is developed. And I think, the hardest one is that it becomes an exception to a no pets policy. So that's where we see sort of the biggest friction. Well, I don't want pets. Well, an emotional support animal is not legally classified as a pet. So it is that accommodation or that exception to the no pets policy. Melissa, do you have more to add on this? I don't know how frequently you see these types of cases. I get a lot of questions about emotional support animals.
Yeah, it's the number one case that I see. It's tricky. There's, there isn't a ton of guidance. It's still pretty open area of law, and I think, like you said, the number one thing to remember is that it is an exception to a no pets policy. So just do not consider it a pet. Don't ask for, a special payments or money related to that, to deposits, and it's, I think it was surprised me when I first started doing this area of law about that, the request can be made at any time. So I've dealt with that a lot with landlords being very frustrated that the animal was not disclosed initially. And in the law, it doesn't have to be. And, and I talked to tenants about that, because sometimes tenants are afraid that if they disclose that they have an emotional service animal, that they're not going to, the landlord won't rent to them.
Right.
And so, it's a balance.
Right.
And yeah,
exactly. And I do want to be clear that there is, I think, a perception that if an animal is classified as an emotional support animal, that the landlord then has no control over setting parameters for behavior or other sort of issues. And that's not true. So you can have an addendum related to that emotional support animal. The recommended addendum that I use looks as almost exactly the same as the one as I recommend for pets, because it's related to the behavior. You can still have reasonable restrictions on picking up after the animal. It can't disturb the neighbors. It has to be under control. It has to be licensed in accordance with local ordinance. If it's a dog, has to be up to date on vaccinations. So tenants responsible for damage of the animal. So it's not a free for all on the animal's behavior. And I will tell you, I have successfully evicted tenants for violating those provisions with an emotional support animal. So the courts will uphold those addendums, and they will look at the behavior. And if it's not, in that particular case, it was a very aggressive dog that the tenant couldn't control. So it's not this just, it comes in as an emotional support animal and then you can't do anything about the animal's behavior.
We've got a couple questions that are pertinent to this, and I think, all of us may or may not remember, I think it's 2-3 years ago, I think I read a story, it was on the internet, so it had to be true. Where a peacock was brought onto an airplane as a service animal. And obviously I'm not dismissing that individual, but people question, is there any types of animals that are over the top, stuff like that? And I'm going to guess, Melissa, the answer is really no. It's more dependent upon the individual in what
that was the case, and that has begun to change, but both with the airlines and with within the Fair Housing Act. So HUD put out some new regulations like a year ago, saying that if it was a non kind of more common household animal, that a person would have to show why they needed that kind of, so basically if it was an exotic animal, they would have to show why they specifically needed that. So this just came out within like the last, it might have been, I don't know if it's the end of 2019, beginning of 2020. So there has been a little bit of movement towards not allowing like peacocks or animals. It was at least having to show why you need that specific animal. So they are looking towards narrowing in on what would be an emotional, appropriate emotional support animal, and the airlines have really made moves towards that. So I think that HUD is seeing that there might need some changes, that it has been kind of wide out there, and we'll have to see what kind of changes go into effect.
Right.
But then,
I mean, the other one that might be nice to have some guidance on is the number of emotional support animals, because right now there is no guidance that indicates a specific number or restriction on the number of emotional support animal requests. And so that's another really sort of gray area for landlords, is how many is too many? Or when does the number of requests become unreasonable is maybe sort of the better question to ask.
yeah, so you still have to get a professional to say that you need the additional animals, but that's it. Yeah, there's nothing else providing guidance.
Yeah.
So,
Go ahead, Brian.
So as we have some questions in the chat, we've got one individual asked a little bit about landlord assistance. I think that was Deborah. We'll politely answer that toward the end. But moving along specifically this topic, we had one person ask, if a tenant's on disability and ask me for a request for accommodation specifically for COVID, am I legally required to meet that request? The tenant's not allowing them in the house.
I mean, this is a super challenging area, given sort of the global pandemic situation that we are in. I think the inquiry is there another reasonable alternative to keep the tenant safe? So a blanket prohibition of requests by the tenant of not to access the unit at all, I think is and would be considered unreasonable under the statutes. The question is there another way to protect the tenant while allowing access to the landlord? Is there a way to mitigate that concern? Melissa, do you have thoughts on that?
Yeah, it's really difficult. I don't think there's any clear answer that can be provided, just because things are changing so rapidly and there's just not a lot of guidance. So I think Angela, your advice is the best that can be given, and just
and if it feels like we're hedging a little bit, the problem with fair housing and all of these rules is it is so fact specific to the circumstance. So let me give you an example. In that situation, if the landlord needed to gain access to, say, show the unit to prospective tenants, a possible solution would be, could the tenant who's there take a video of the space or take pictures of the space to provide to the landlord to do a more virtual type showing? Or would the tenant who lives there be willing to do that virtual showing for people who wanted to see, walk them through the unit on FaceTime or Zoom or one of these other situations, as an accommodation to not having people come in their unit? It may be different if there's work that needs to be done inside the unit, or some sort of safety inspection, lead paint inspection, or other type of reason for access. But it really, what the appropriate solution is or outcome may depend on what the reason is for the access.
And I would concur, and probably everybody can appreciate this in our audience. Some of these are so case specific that the best thing they can do is join the Apartment Owners Association, reach out to you, Angela, and talk with you, or possibly reach out to Melissa and just get some guidance. Because I'm a firm believer, such as the instance that I mentioned that I dealt with your office, Melissa, is that if I was forward in communicating, seek to be doing the right thing, asking reasonable questions, all that would be reflected in whatever outcome if there's a complaint. So moving along the line with some questions. We had one from Tracy Sorensen. Great to have you on, Tracy. No medical note needed, just take the word?
Well, you need verification from a person with knowledge. That's actually what the federal statute says about it. Generally, it comes with a note from a doctor or other healthcare provider. But the legal standard is a person with knowledge, and it's not the applicant themselves. They need a third party to verify that they have a disability and the request is related to the disability. They don't have to disclose what the disability is, just that if we're talking specifically about emotional support animals, that animal is needed to alleviate some symptom of their disability.
Excellent.
Yeah, and just be careful not to ask for medical records or not to, dig too deep, because you're entitled to exactly what Angela said, but you're not entitled to dig too far into people's, personal lives and medical issues.
Correct. It's a pretty, and most medical providers, if they're providing that type of note or letter, they understand what they can disclose and not disclose. And so you're not going to get too much more information than so-and-so has a disability and a cat would help them with their disability. You may not get more than that.
Being a cat lover, I can appreciate that. All right, the next one along from Taylor White. Great to have you on as well, Taylor. Hope all is well. What if someone's insurance policy does not cover particular pets? Can we deny the coverage? Because that's a really interesting one. You got to keep the building insured, but
so here's my recommendation. If something like that comes up, more and more insurance companies have moved away from a banned breed list, particularly as it relates to dogs. So have moved away from that model. What I would recommend doing if you're in that situation and you have an insurance company that has a list of breeds that they will not allow, is to make the request in writing. We have a tenant, we've received a reasonable accommodation request for animal X. Animal X is a pit bull breed on your banned breeds list. We are asking for an exception as an accommodation, right? So you're almost using the same language that the tenant is, asking for an exception to that policy. If you get a written denial, and you would want it in writing, don't take it over the phone, because if somebody files a complaint against you, you're going to want that written paper trail. If you get a denial, you have more likely than not set up a situation where you have a legitimate business reason to say no. Now, notice I'm using some language that is you may have, right? This is not, we're not talking in absolutes. These are the types of situations that you need to talk through with an attorney or somebody familiar with how this process works, because this is an incredibly sort of thorny area of the law. But you do need to go through those steps to try to get that animal approved with your insurance company. Melissa, what have you seen with this?
Yeah, I have not had it actually appear in front of me as the case. So it's more just what I've researched and what's come up in my own trainings. And it's difficult because HUD doesn't use that as I mean, they specifically say you can't discriminate based on breed. So it's definitely a conflict that's out there, and I have not seen it resolved. So I think Angela's advice is really good, and but I don't know for sure if that would be a sure thing as a defense or not. But I think that's really a good step and good advice to go through. But it's one of those frustrating things that there just isn't anything clear in the law right now on how to handle that.
Right. And I have seen over time a move away from these banned breeds lists, and I think it's for this reason.
Okay, I didn't know that. That's good to know.
Well, I once had somebody applied. There wasn't a special needs situation, with a Doberman, and I just actually called my insurance company because and I'm a generally a pet friendly landlord, and the insurance company just encouraged me, ask them to verify the dog hasn't bitten anybody. The tenant disappeared. So I'm going to guess that means that dog bit somebody. So I don't know if that's a question you could ask, to help get an insurance waiver, for that. I think we've got a couple more right on this sort of topic. One person asked if they have and I'm going to guess the person, I'm going to guess the answer is no, we cannot do this. Are we allowed to require additional deposits, for support animals?
So the answer is no. You can't take any extra deposits or collect any extra money if the animal is classified as an emotional support animal.
Excellent. And I believe anonymous attendee, when he asked about elaborating the documentation, I think we just answered that in the prior question. I think we're good for questions right now.
Okay, so I think we're gonna step over to sort of one of the other topics where we see a lot of friction come up. And I think, Melissa, you can maybe confirm that you see complaints at this point of the process. So this is somebody who is looking to rent, isn't a current tenant, but is trying to find an apartment. And so, the advice that I always give landlords when you're renting a unit is treat everybody the same. It seems like that's a no-brainer, but you would be surprised that doesn't happen. And one of the ways that you can do that is to make sure you're showing the unit to everybody who wants to. And I know that's become a little more complicated with COVID. So however your process is for showing, whether it's virtual showings, whether it's sort of open houses, I think a lot of landlords have gone to virtual showings and sort of pictures only because trying to access units is very challenging and difficult right now. But the other piece to that is give everyone an application. Don't do sort of this like pre-screen, ask a couple questions or read an email and see some things in there that maybe you don't like. And so then just don't respond to that person. Like, you need to have a process, respond to everybody that makes an inquiry, give everybody an application, screen everybody the same way. And, I think always the big takeaway when we're talking about fair housing is it's the tenant's job and it's the tenant's right to determine if a particular unit is suitable for them, their family, and their situation. And, we see this come up a lot with, kids. Oh, well, I don't think the unit's safe for a family with kids, or it's right next to a busy road, or it's right next to sort of fill in the blank. That's the tenant's obligation and job to make that decision about whether it's suitable. Do you have thoughts, Melissa?
Absolutely. This is just wonderful advice because we do see so many complaints come in where people are turned away and not given an application. And so that it leads people to say, like, what have I disclosed so far that might be causing them to say no without even giving me an application? And that's when they go back to thinking like, okay, well, what do they know about me? They know I'm African American. They know I have a housing voucher. They know, I'm on disability. And those are like, they're like, well, those are the only things they know. So those must be the basis of why they turned me away. So I agree. Just give everyone an application. Over the phone, when people do the screening and just ask certain questions and then turn people away and say, I don't think you're a good fit or something very vague. I mean, that also can lead to those outcomes. So I think this is excellent advice. I fully support that.
Yeah, and I know the reason why landlords use pre-screen is to cut down on the workload. And if you're getting, 100 inquiries a day for a unit, like it's a lot of work and it's a lot of effort. But it's one of those things you have to think about and consider implementing, because otherwise you are potentially setting yourself up to deal with a claim, and it may be a claim that you can't defend and can't prove that you didn't have a discriminatory reason for saying no or not responding to an email or pre-screening that person. So it's just important for consistency and also just to have that process, right? Because then well, with every tenant or every inquiry, I respond back with the same thing. And it is, here's an application, here's where you can look at the unit, please fill out the application and return it to us, right? So if you do that every single time, then there's no question that you're following the same process and treating everybody the same.
Absolutely.
Do we have any questions, Brian? Anything coming up in the chat?
The only thing that came up was actually more to do with pets. What if other tenants have pet allergies? We just had one more added in. What if other tenants have pet allergies, but the other, one tenant wants an ESA?
Yeah.
So I'm envisioning a duplex. We got one side says they're heavily allergic, and the other side saying I need an ESA.
So unless the position has changed, my understanding is the Human Rights Commission's position is that disability trumps allergy. And unless there's some other reason, like the tenants are sharing an actual physical unit, that wouldn't be a basis for denying the request. Is that still accurate, Melissa?
Yeah, I think it is. I mean, I think the dream is that everyone sits down, not necessarily us, but the parties sit down and look at what other apartments are available, what other things could be done to, limit the exposure, like air purifiers, if there's, or apartment swaps, or what else can be done to try and make it work out for both people. Always. And that's always the hope. But if not, yeah, I think Angela, if we have to get down to it, that is correct.
Yeah.
Great, great angles. We got a couple ones that actually just popped up quick. I understand we're not able to charge application fees, but we are allowed to recoup our cost correct. I'd love to take an answer on this one. You guys tell me if I'm right. As long as your policy is uniform and you're charging everybody a credit bureau fee or something like that, my 2 cents, as long as your policies and practices are uniform, I believe you're okay to do that. How'd I do? Did I fail miserably or did I do all right?
And as long as it's the exact charge that you receive from whatever that third party vendor is.
Excellent.
Right.
Next one.
Melissa, is that the position that the Human Rights Commission would take, or at least from what you've seen?
That's a little more landlord tenant than we get into. So unless, you were charging someone of one race, one cost, and of a different race, different cost, we probably wouldn't get involved. But yeah.
Yep.
That would be how.
Okay.
Yeah. All right. We got another one. This person initially asks their income. They generally use a 30% formula, not too unlike mortgage companies, where affordability, how many potential tenants do not qualify simply due to or many potential income or tenants, if I can speak today, do not qualify simply due to their income.
Yeah. And again, I think that's a consistency issue. So as long as the policy is consistently applied across the board, it's okay, or generally okay. Yes. Okay. I'll stop there. Melissa?
Well, there could be reasonable accommodations that could come up that may, be something that a landlord could consider. So I know of at least one case where the landlord typically did accept co-signers, and there was someone on disability that had a good credit rating, had always made their rent, was looking to rent at a place, and asked for a reasonable accommodation to have the mother as a co-signer, and they denied it. And I believe that the court ruled that that was a reasonable accommodation. So sometimes, it's rare, but sometimes you'll have stuff like that come up. But otherwise, it's not problematic. You're entitled to get paid rent.
Excellent. And I would just encourage that person just to make sure you've applied it to everybody. Just because you make certain exceptions, the exceptions may have been made of good reasons, but those exceptions could look discriminatory. So I personally, my 2 cents, I'd be very, very cognizant of that. One more on this. Can you request an application before showing the unit in person to someone? I'll take a crack at that. I can imagine through the pandemic, is that an issue? I'd probably say it wasn't an issue, so long as uniform practice.
Yeah, I think definitely. I think uniform uniform practice. Though you can kind of see the chicken and egg problem here, where, you know, the person who's applying wants to be able to see the unit to decide if it's going to work for them before putting in an application. You know, landlords trying to minimize the number of people in the unit. So I just, you know, I'd be careful with that one. I don't think it's running afoul of any rules, and I think you can justify it more right now, given the current situation that we're in. But that could change as things reopen and sort of restrictions go away. That might be one that you want to revisit your approach to that. Just because it has the possibility of creating impediments to people to get housing. So
Great point. I think we're tied. We're good on this one. We're good.
okay. So one other area that I wanted to talk about a little bit is statements. So this is both sort of written and things that you say, and just more of sort of a reminder to be mindful about how you phrase things or how you say things, right? Because how you talk and the words that you use or write could be considered discriminatory. And it can be a challenge. So one of the things that folks say is, well, but I didn't mean it that way. And I think the hard part is that intent and sort of what you meant isn't really the standard here. So was it said or was it written? And so just, be mindful of that when you're communicating with people who are applying or communicating with your existing tenants. I don't know, Melissa, if you have any more advice on that for folks.
Yeah, there's a lot of, small landlords that deal directly with people renting. And I think, we're a small friendly state, and sometimes you do just speak off the cuff more. And so we do get a lot of complaints where people just, feel comfortable or having a conversation and don't realize, what they're saying could be construed as offensive. Whereas, in other places when there's really big landlords, it just is different. The property managers might just deal with individuals differently, and so that does come up, and people, you just got to think about what you're saying. And it's, it is a professional relationship between the landlord and tenant.
Yeah. And it's, it's hard, and, language changes over time as well. So I think that creates some challenges for everybody as well. So Brian, do we have any more questions in the chat? We can open up sort of more generally to stuff.
So we have one more. Statements are a tough one. I know it's hard, to know what will be taken the wrong way. Any common examples that come to mind? I guess I'll take a crack at one. Great family. This is a great family unit. This is great. This is starter for a great. And we see for the real estate agents on here. I hate to tell you, we probably violate this more than we intend to. Great family neighborhood. Easy walking distance. I think is also a violation. So I would really spin whatever you're going to say 360 degrees to make sure it's not impacting in a negative fashion anyone who's in a protected class situation. And just little creative things like short distance to market as opposed to easy walking distance to market. Great neighborhood as opposed to great family neighborhood. That would be my 2 cents for easy examples.
Right. You could flip that. Quiet neighborhood. Right. I have 2 very loud children. And, if I was applying in to rent for something that said quiet neighborhood, I might steer clear of that because the expectations may not match up. And that's not, but I should be able to rent there with my kids, even if it is a quiet neighborhood. Right. So that's, That's the type of thing we're talking about. And it is tough, right? Because you want people to be happy and be in the right place and not have a successful tenancy, right? We don't want to set people up to have conflict with the neighbors or not have a good experience. And that's the challenge. And we want to be helpful, right? we are helpful as a species. And sometimes I think that's, what Melissa was getting to with the, that relaxed sort of, Vermonty thing with, hey, I'm just looking out for you, can sometimes come back and sort of bite you from a fair housing standpoint.
We got one more question, and I'd love to take a crack at this one, but I think it's actually an interesting one. None of our current landlords are signed up for Section 8. I usually refer potential tenants to a local company that specializes in Section 8, not accepting Section 8. Is not accepting Section 8 a problem? My personal answer, and challenge me on this one, is it's a hotly debated topic. My recommendation, you guys correct me, is my response always was, we would consider all applicants equally compared to the next tenant, irregardless of their source of income. Meaning that I've had personally phenomenal luck with Section 8, bad luck with Section, just like I've had good luck with non-Section 8 and bad luck with non-Section 8. Melissa, any 2 cents on that?
Yeah, I mean, you can't discriminate based on source of income in Vermont. We're, many states that's not a protected category, but Vermont it is. So
right.
yeah, you can't turn
right.
someone down based on that.
Right. But I think where it gets challenging is there is sort of the exemption for if you have a legitimate business reason for a denial, you can deny on that basis. Now, the question is, I only have month-to-month leases. I don't do anything but month-to-month leases. That's my business practice. It works in my business model. Section 8 requires a 12-month lease. Is that going to be enough to say I have a legitimate business reason to say no to Section 8? My guess is probably not, unless you had some more things that could fall into that category. But that's where it gets, tricky with that. It's possible that the program doesn't mesh with how you operate and how you do business. The only way you're going to find that out is by making those inquiries, doing some work and some legwork with Section 8. What are they going to require? How does this fit into my business model? It's a lot of work to go through. You have to be able to prove it and have the documents to back it up.
Yeah, and I will say that I have not had that happen yet. And I haven't been at the HRC forever, but I haven't had anyone go through that yet.
Right.
So I can't really provide any guidance on that specifically.
Right. And I think, that legitimate business reason, that's a pretty high bar.
It is.
To get over, to say, I can say no because it doesn't fit into my business model. There's a lot of effort that's going to go into that to meet that threshold.
Yeah, I would personally recommend against such policies. Because I think, again, you're going to have, people that I was once referred to as the stink test. If you're in a courtroom with 12, juries that don't know you, is there an odor? And if there's an odor, you got a problem. We've got a couple more questions that I think will actually shift us to some other general tenant stuff. And with everybody on, we love the questions, but I'm also going to guess you are excited to hear about, what Angela has to tell us on the tenant updates. Melissa from the Vermont Human Rights Commission, great to have you on. And as anybody heard, I dealt with these folks years ago. I had a unanimous decision in my favor, but I will say they were phenomenal to work with, took the educative approach, gave me ideas of how I could improve, while also were very pointed where maybe whether it well-intended or otherwise, should have done better. Melissa, any final comments? And we thank you profusely for joining us today.
No, thanks so much for having me. I appreciate it, and feel free to reach out to me if you have any questions. Go to the HRC website, and you can easily find my number and my email. So thanks so much.
And Melissa, you are doing some more seminars because April is Fair Housing Month. There are more seminars upcoming if people want a deeper dive into some of these issues.
Absolutely. I have one I'm doing with legal aid tomorrow on voucher discrimination, as we were just talking about. So that is from 1 to 2, and the information should be available on the HRC's Instagram and Facebook page. And then on Monday, we do I do a fair housing training every second Monday of the month from 9 to 11. And you're welcome to contact me, and I can provide you the Zoom information for that. So enjoy the rest of your day, and thanks again for having me.
Melissa, thank you very much for all you do. I appreciate it.
You as well. Thank you.
Thank you.
So Angela, let's go with 2 questions from Dana Bresser, who, thank you very much, just asked one of the first questions and one of the last ones to answer. So we have 2 questions from Ms. Bresser. Assuming this will be covered, but I specifically want to know, is there any possibility that I should not apply for rental landlord assistance if I plan to evict a tenant as soon as possible when the moratorium lifts?
So here's what I'm being told, and here's what I've seen in the regulations at this point. And I'm saying at this point because it could change down the road. At this point, there is no restriction on starting an eviction if you take rental assistance money with this new program. Clearly, well, not even clearly, if the tenant owes you money and the whole back rent part doesn't get paid, but you're getting rent going forward, you are not having a restriction placed on you to evict for non-payment of rent when the courts reopen. I want to be clear, this is for the Vermont Emergency Rental Assistance Program through Vermont State Housing Authority. There is a second program that the Agency of Human Services is running for their reach-up tenants. So they're tenants that participate in various assistance programs already through them. They have some different requirements. And I understand eviction restriction is one of them. So just make sure that you know which program you're in. If you're in reach up, they've already reached out to you if you have a reach up tenant about it. So if you're doing your standalone application through Vermont State Housing Authority, that program as of this time does not have an eviction restriction.
Excellent. And same individual, Dana, thank you very much again for your time today. What about statements for references when tenants are moving out? I cannot answer honestly and give a reference that will help the move out. Angela, I'm going to take the guess. No answer speaks volumes.
No answer does speak volumes. I would also say when you're giving references, stick to things that can be verifiable, right? So it's very easy to verify statements of rent. So tenant paid rent late, they always manage to get caught up, or they paid late and they left owing me money, right? That's all verifiable. Versus, well, the tenant's a giant deadbeat and never paid his rent. Those are 2 different statements. You've kind of said the same thing, but again, it's this words matter, right? And how you say stuff matters. So stick to things that can be verified. And I would say, I would agree with Brian, the no comment or I can't answer that question should speak volumes if you're on the receiving end of that. I need to go get more information.
With humor, I would joke if I can remember them, it's usually not a good thing. If I can't remember them, they're great tenants. So Angela, we got about 7 minutes left. What is going on in the world with President Joe Biden, whether you love him, hate it, voted for him or otherwise? Is he bringing us to the promised land? We're gonna have money for our tenants due to COVID?
Kind of. So Vermont has approximately $352 million. Yes, you heard that correctly. $352 million for rental assistance. However, that $352 million has come with a lot of restrictions on how and who the state can provide assistance to. So this is one of the reasons why, with the new rental assistance program that launched on Monday, the landlord portal is not yet open. I am being told it may open tomorrow. If it doesn't open tomorrow, it'll be early next week. So that's the portal where the landlord can go to put in their information to get money and payment. There's a lot more requirements. Tenants have to have their income verified. They have to show need or some hardship related to COVID. It's not the like 2-page application that you filled out for RHSP with no verification. So it's a little bit more of an onerous process. It is all through an online web-based portal. So the hope is that the access is easier. It's going to be easier to track. It's going to be easier to see when payments are made. I'm told this new system and new program has the ability to make payments on a weekly basis. So there's going to be a much quicker payment turnaround for folks who are applying in for the first time. Once you apply in and your tenant gets accepted, there's going to be less work going forward to maintain the approval. So approvals can be for either 3 months at a time, and then there's a quick certification at the end of the 3 months to keep going forward. Or if your tenant provides, say, a tax return type documentation for income verification, they can actually get a 12-month certification and verification, which means you'd be looking at monthly payments for 12 months without having to do another certification. So some of it depends on how the tenant certifies their income to participate in the program, but you're not going to have to go reapply every month. That's sort of the takeaway. You may have to do something every 3 months, but not every month once the tenant qualifies. The things that the landlord has to certify to participate in this program, you have to certify that you're not going to increase the rent during the grant period. There are a few exceptions to that, but for the most part, you have to keep with whatever the rent is right now, mostly because they don't want people taking advantage by, saying, well, look, we're going to bump the rent like by 200% and, the program will pay for it and everybody, is happy. So they don't want that to happen. That's why that restriction's in there. You have to, again, attest and say there's no life safety issues in the property. That was a requirement under RHSP. And then the third thing is that you have to agree that you will take a referral and take a look at weatherization programs. Not that you'll participate or do a bunch of work, but that you'll take a look at it and get some information about weatherization. That's it. That's all the landlord has to do besides provide the program with their contact information, bank account information, W-9 information. So very limited restrictions on the landlord this time.
Excellent. No, it seems like it's going to be a little bit smoother, and it seems like it's well funded too.
Yes. I think the other thing that we can maybe expect sort of coming down the pipeline are some funding for rehab of units. So there's the state is trying to make permanent the housing investment program that ran for a short time in 2020 with some COVID money. And so this was the program where landlords could apply in to get a grant up to $30,000 with a small landlord match. This was going to require like a 20% match. So basically you get up to $36,000 worth of work for $6,000. So, it's not, there's some restrictions in that and who you can rent to and having to keep the units affordable, but it's a program that I am hoping the state can make permanent because it was very successful. It rehabbed like 250 units in 2020, getting them up to code, getting them new windows, new things to make them better housing units. So, There's some stuff, there's more money. I don't even, the state has gotten to the point of looking at the American Rescue Plan money because that has even more stuff. The governor just announced his proposal for that a couple days ago. So that's, you know, calling for development of more affordable units, more, you know, there's some opportunities here.
Excellent. Well, we're actually at 12:59. We really appreciate the interactions today. I'm going to just double check one last thing to make sure. We may have a couple quick questions. How do we get give our tenant information about this program? I'm going to suggest that we go to your website or this, you know, VSHA's.
The best place to go is Vermont State Housing Authority. So VSHA.org. And there's right on their homepage is rental assistance. You click that button, it will take you in with all of the program details. That's the place where you would go to apply. When the landlord portal goes live, that's where that will be, but there's fact sheets up, there's other information, resources to call for help. They do have a staffed call center this time. And there are ways to call the call center and get your information put into the system without using the online platform. But definitely, I think that online platform is a lot easier to use than what we saw in 2020 with the RHSP.
Excellent. I think we got one last question. The stipulations on landlords would probably have a larger responsibility, I assume, based upon this landlord assistance program. For example, can evict for the same number of months as payments come in?
No, that was an RHSP requirement. This new program does not have that requirement at this time.
Excellent. So one is really appreciate your time, Angela, and again, everything you're doing for the association and for us landlords out there. Appreciate everybody who joined. We've got some great stuff coming to you in May. I think we'll actually have more stuff about the landlord assistance program or the rental assistance program. I think we've got a couple other things, probably eviction ban updates as the COVID updates. So folks, keep reaching out. Let us know what we can do to bring you better value. And I can't stress enough, I encourage you to reach out to Angela, join her association, or reach out to allburlingtonhomes.com, where his property management company and our team at Stronghold Real Estate can help you further the returns on your investments and hopefully get some more of them as well. Angela, any comments in closing?
I don't think so. Join us in May for, again, COVID updates, moratorium updates. We'll do one more seminar in June, then we're going to break for July and August. And I think the plan is to come back in September with somebody from the Division of Fire Safety to talk about fire safety codes and some potential new changes that are maybe going to happen in that department.
Excellent. Thank you, everybody. I hope this message, or hope today found your family well, and go get those little